Welcome to the Global Operations Group Quick and Dirty 30 podcast, where we take 30 minutes to talk with business operators, investors, and specialists about topics that are important to know for companies entering the U.S. market. My name is Alex Chizik. I'm the founder and CEO of Global Operations Group. And today we have Adam Zarin Esquire with us. Adam is a managing partner of Zarin Law Group, a boutique firm focusing on working with middle market companies, venture capital, and private equity funds. Prior to becoming a founder of his own firm, Adam was a partner with the law firms of Neuberger Quinn, Gillen, Rubin, and Gibber, and Sol Ewing. Adam's primary areas of practice include mergers and acquisitions, restructuring and reorganizations, corporate governance, capital raises, corporate finance, and intellectual property. He focuses much of his efforts on the lower to middle market companies with annual revenues generally up to several $100 million. I've had the pleasure to work with Adam before as a client of his firm, and he helped my company to do a corporate restructuring. And I can tell you that he not only understands the business structures and the law, he understands how businesses operate. They can marry the two for the business owners. That is very important. So I'm also proud to call Adam my friend. Adam, welcome to the podcast.
Thank you, Alex. Same here. I feel feelings are mutual and nice to be a part of it. Thanks for having me.
Absolutely. So I've shared with you, Adam, that my company, Global Operations Group, has entered into a partnership with the American Chamber of Commerce in Ukraine to bring this type of information that we're going to talk about. Today, we're going to talk about corporate structures and how to form companies in the United States. So that information is very important for foreign companies planning to enter the U.S. market. And my partnership with the American Chamber of Commerce will bring those type of podcasts, that type of information on various topics for Ukrainian companies, just so they know what to do before they do it. Because obviously, we always talk to our clients about plan ahead. Don't just dive into it, right?
Absolutely.
Excellent. So we've got 30 minutes to discuss the topic of corporate business formations. I'd like to start with a quick review as to what corporate entities are available for foreign companies as they're planning to enter the U.S. market. And then we'll dive into what the differences are between those entities, why somebody would choose one over the other, where they would choose to incorporate, and I'm sure we'll find some other things to talk about as well. So let's do that. Let's go ahead and just dive right into it. A foreign company, let's say in Ukraine, is planning to enter the U.S. market, right? And the operating entity, they're producing products, or they're in the service business, and they want to open a U.S. Organization, a U.S. company to enter the U.S. market. What's available to them in terms of corporate formation?
So the most common entities are going to be C corporations and LLCs. Partnerships are also available. There's some other types of entities, but let's focus at least initially on C corps and LLCs. There's also, for your clients and others that if they hear about an S corporation, that there's some favorable tax treatment that's only available for U.S. persons. So we'll skip that one
right.
for this, unless you want to get into it. But for C corporations, the C corporations have been around forever. All the largest companies in the United States that are publicly traded are C corporations. Laws generally well settled for C corporations. They're one of the, and tax drives a lot of these sort of decisions and processes. When we have foreign company clients that are choosing to operate in the U.S., we look at in terms of the types of entities, and we bring in our tax folks to sort of help out with that. But generally, we'll see C corps or we'll see LLCs. So with a C corporation, there's more in terms of there's more paperwork than LLCs. There's a double taxation with C corps, which means that there's a tax at the corporate level based on income, and then if there were distributions to shareholders. So if there's a Ukrainian company that had owned 100% of and formed a C corp in the U.S., and then the distributions made to that entity, then there would be a double tax there. Now, under Trump's plan a number of years ago, the C corp tax dropped down to 21%, but it looks like that's going to be increasing under Biden's plan in the coming days, weeks, and months.
Right. So if a C corporation is subject to double taxation, let's talk about LLCs and talk about the taxation there, because that's really one of the first questions the companies ask, right? What a corporate entity do we choose? And the first consideration typically is how they're taxed. Secondary consideration or secondary questions typically are what's the differences in operating those entities. So tell us about the LLCs, how they're taxed, what are the differences in LLCs, because there's a couple of different ways one can form an LLC in terms of how it's taxed.
Sure. So with LLCs, they're considered they're a new sort of entity. I say new, and they were basically sort of started in the 90s. But that's relatively new compared to corporations. So the law isn't as well settled there. There just hasn't been decades and decades of lawsuits and cases. As a former litigator, you certainly can understand and appreciate that. So it's not as well settled. Generally, if you had a Ukrainian company that was forming an entity and we're just going to own 100% of an LLC, in the U.S. it's disregarded for tax purposes. So the parent company, essentially, it would be reported as income, and income and loss would be reported at the holding company level, the entity that owns it. But at the same time, a lot of times foreign companies will come into the U.S. and do joint ventures, and there'll be more than one owner. If there's more than one owner, then the default rule is it will be taxed as a partnership. You can also make an election under U.S. law to tax an LLC as a corporation, as a C corp, or as an S corp. So, with LLCs, there's a lot more flexibility in terms of governance and how they sort of are organized and how they operate. With a corporation, it's much more statutory. I mean, there's statutes in place at each individual state, but at the same time, corporate law is much more settled, as I was mentioning before. So, I could sort of explain, if you want, the basics of the differences between, from a documentation perspective, at least at the outset, we typically see between the two.
Yeah. So let's talk about that. So we touched on the taxation element, where the C corps are taxed at the corporate level, and the C corporation files a tax return. And then if any funds are distributed to the stockholders, then they pay an income tax on that as well. And then the LLC itself doesn't pay any taxes, but the income is passed through to one owner or multiple owners, and they pay the income tax on that. They file the tax return on that income.
If it has one member, and as long as it doesn't elect some other sort of tax treatment.
Right.
There's other things you can.
Right. So as a partnership, that's what happened. The income tax would pass through to the members. If the LLC elects to be taxed as a C corporation, which it can do, as you mentioned, then it would pay a C corp tax on the corporate level. And then the owners, the members of the LLC, whether it's one or multiple members, would then pay the tax on their income. So very similar. It basically ends up being the same taxation as a C corporation. But yeah, let's dive into what the differences are in operating the different entities.
So just at a very high level, and we could then drill down into some more details. So for a corporation, you have the shareholders who own, one or more shareholders that own the business. They then elect the board members, the board of directors, who then sort of oversee the operations of the business. And the day-to-day is managed by what's known as officers: president, vice president, secretary, treasurer. A lot of times there's a chief executive officer and other C-level titles that are utilized in the U.S. And other countries. But just generally speaking, for a corporation, that's the general sort of structure. There's potentially certain options to elect out of having a board if it was a closed corporation where the shareholders would make the decision. But you probably wouldn't see that for foreign entities that are basically forming businesses to do business here. That would make more sense. Let's say you and I wanted to form a business and have some venture, and it's two of us. We could elect to not have a board, and we could just make the decisions at the shareholder level to appoint officers. So what you typically would see from a documentation perspective, for an LLC, or a corporation, you have a charter. Different states call it something different. You generally see for a corporation it'd be called certificate of incorporation or articles of incorporation. It has just some high-level details, the address, usually the names of the initial directors could be in there depending on what state you're in, and some other sort of high-level information. It doesn't get into the owners at this point. There's been a lot of talk about sort of digging a little deeper so that owners of businesses becomes public information. Right now, it's not. With an LLC, they usually call it a certificate of formation or articles of organization or something along those lines. That's the 1 to 3 page document, 4-page, 5-page. I mean, it could be longer, but that's normally we see the ones that getting filed at the state level to actually form the company. Now, once the company's formed, a corporation will have, a stock ledger and stock certificates where certificates are actually issued that will show how many shares are issued to each particular shareholder. And that's an instrument that you basically could hold on to that reflects the fact that that the shareholders have ownership in the company. With an LLC, you don't normally see that. Once in a while, banks require that so that when they take liens, they can easily collateralize and perfect their liens through certificates. But generally, you don't see stock certificates or unit certificates for an LLC. So then for a corporation, what you normally see are bylaws that sort of lay out a lot of the governance, and then shareholders agreement or agreements, and that generally, if there's multiple shareholders, that'll get into voting and buy-sell language in terms of what happens if it's individuals, if something happens to somebody, if it's companies sort of coming together, if things aren't working out, or if it's a 50-50 relationship and there's deadlock issues, those sort of things, for a corporation. And corporations are more formal too. There's generally a requirement to have an annual meeting of shareholders and an annual meeting of directors, if nothing else, to have the meeting of shareholders to appoint the board, reappoint the board, just depending on the situation. And then in turn, immediately following that usually is a meeting of the directors that would then appoint or reappoint the officers. With an LLC, you don't have to go through that level of detail. You have the governing document for an LLC is generally referred to as an operating agreement or a limited liability company agreement. Different states call it different things, but those are the general 2 terms of art that are used. And within that document, you could sort of get into a lot more detail. And with an LLC, there's a lot more flexibility. You don't need to have a board. The members, the owners of an LLC are referred to as members, whereas the owners of a corporation are referred to as shareholders. Sometimes members are referred to as unit holders because, like in a corporation, stock gets issued. With an LLC, you don't actually have to issue stock or anything. Actually, it could just be a membership interest, a certain percentage ownership in the company. If you and I formed an LLC, even if we were foreigners, we could own it 50-50, and the operating agreement could just say we each own 50%. It doesn't have to say we each own X number of, a lot of times you refer in LLCs as units instead of shares. We don't generally get into that. In the more sophisticated sort of transactions than LLC interests are usually put into units or shares or call it whatever. Now, one other thing to be thinking about too, with foreign entities that are going to be doing business here, normally there's a separate management team and there's some separate folks that are on the ground here. So in that sort of scenario, I'm not going to say at this point every situation is different, that a corporation makes more sense, but the sort of governance around a corporation with having some sort of board would probably make sense. But it also depends on the details. I mean, we've done this many times where it just sort of is linear, and the owners of the foreign entity could make the decisions in the U.S. without needing to set up any sort of formal governance.
Right.
But that's usually all spelled out in the operating agreement.
Right. So with corporations having slightly more, somewhat, and probably not even slightly more, but just more of a requirements for formal documentation, and LLCs being more flexible, it doesn't stop the LLC members, like you mentioned, from adopting some of the operating guardrails and guidelines that a corporation would use because of that foreign local, difference in operating of in owning the company and really running the operations of the company from overseas. They can have a board when there's an LLC. They can have obviously the different operating positions, president, CEO, C-level positions, things like that. But what are some of the conversations that you have with your clients when they're, after they've been educated on the difference between the C corporation and an LLC? What are some of the decision drivers that would that would make a foreign company choose one over the other in terms of going here?
So that's a great question. So I think I was saying earlier, for an LLC that has more than one owner, the default rule is it would be taxed as a partnership. So a lot of times, especially for, not especially, but many times for foreign entities that are doing business here, they're going to have some folks on the ground. A lot of times they may want to provide some sort of sweat equity or incentive equity to go along with it. And there's different ways to do that. But if the intent is really to provide pure sweat equity, meaning they're providing services and not basically buying in for fair market value, they're not buying the equity for fair market value, then you certainly would want to have an LLC sort of in the mix. Now be the entity that you'd hold the equity through, because under US law, there's an easy way to sort of get equity into the hands of folks that are not paying fair value for the fair market value without having to pay tax on it. Whereas with a corporation, if you and I formed a corporation, whether we're in the US or we're overseas, and we were providing services in exchange for the equity, the value of that equity will be income to us and taxable. Now, there's ways around that with issuing warrants instead of straight equity, or issuing options instead of straight equity. But at some point in time with options, there's a strike price. So at some point, either I'd have to come out of pocket if I was one receiving it and have to pay, or you can do what's known as a cashless exercise a lot of times, where you just wind up getting less, but you can use some of the value in the equity that where it's already appreciated, to use that instead of actually coming out of pocket with cash, the appreciation. But just at a high level, if one of the first questions we always ask clients, whether US or non-US, is, are you intending to provide some sort of sweat equity? If the answer is yes, then it would make a lot of sense to use an LLC to get around the taxes.
It becomes a little more appealing on that particular issue.
From that perspective, absolutely. Now, one of the other things to just keep in mind too is a lot of times we use both. Sometimes you could use an LLC that be the operating company, have that owned by a C corp. One of the benefits of the C corp, use C corps a lot of times for foreign investors that are coming to the US and they don't want to have. So with an LLC that is either a single member or multi-member LLC, it's a pass-through entity, so the income gets reported at the members, the owners' income tax. And so the thing is, with a sorry for the phone ringing in the background.
No worries.
With a corporation, you don't have that. There's the tax 21% currently. 1% at the entity level, and then distributions, upward, but you don't have the same sort of pass through. So, a lot of times owners of entities want to avoid what's known as phantom income, where they're going to basically have to pay tax off of phantom income if they're not actually distributed funds. So, so C corp gets utilized a lot of times for that. And, a lot of times, your clients and others may hear of a blocker. there's a concept of a blocker. That's usually just putting a corporation in between the foreign entity and the U.S. operating company, so that the tax sort of gets caught there, so there's not phantom income that basically goes on to the foreign investors, or even the U.S.
What about a choice of entity for companies that are expecting to raise money here in the United States? Let's say a technology company that has experienced some runway success in Ukraine or maybe worldwide, and now they're opening the U.S. entity, but they're really opening it to raise money eventually to go public, versus a products company that's coming in to manufacture something here, and they're going to be an operating entity, kind of organically growing it over a period of time. What's your advice to one of those situations?
So that's a great question. So under U.S. tax law, it's better to be an LLC or an S corp. You can't be an S corp for foreign investors, but to avoid the double taxation, it makes more sense. Generally, there's exceptions to every rule. Every situation is different, but generally, it makes more sense to be an LLC and have the flexibility for as long as you can. We see a lot of times with companies, a lot of times VC and other investors are okay investing in LLCs. They historically weren't, but more and more of them have been more comfortable, but still many aren't, because they don't want to have phantom income issue. So at some point, a lot of times the LLC would then convert to a corporation. Either check the box and elects that,
to be taxed as
treatment.
One, right?
Yeah.
Or actually convert to one.
You usually see the conversion, and actually within the last 10 years, a lot of states have adopted with some as a conversion statute, where it's much simpler to be able to convert from an LLC to a corporation, or vice versa. And there's tax implications potentially depending on the particulars of each particular situation, but at a high level, that made things a lot easier. And historically, we would have to do it by merger. So if there was a corporation that wanted to be an LLC, we would have to form an LLC and then merge the corporation into the LLC. That's now avoided with the conversion statutes in most of the states, if not all states. I don't know, the specifics on every single state, but most states, and the states where companies are going to be organizing the entities for the large part, there's a conversion statute.
Right. Okay. So that's actually a good segue into probably, if not the first question, and the second, most common question that a foreign company owners would ask as they're planning an entrance to the United States is where do we incorporate, right? We have 50 states, we have Washington, D.C., we have 50 different legal jurisdictions, tax jurisdictions that vary widely, from 0 tax to 12+% income tax on individuals, from 15% to 20-some% on corporations. Then there's also the federal level. So different formation requirements, different operating requirements for different entities. So that's typically if not the first question, where do we ask? So I know I have a pretty thorough discussion with companies in terms of covering a lot of different aspects in terms of tax, tax formation, kind of legal aspects of things, but then also get into the business sides. Well, where are your customers, right? What kind of employees do you need? Because United States is a big country with a lot of differences in terms of cultures, politics, education level, different educational and experience kind of focuses, industrial versus technology, this kind of pockets that we have here. So let's talk about some of the conversations that you would have with your clients to the question, where do I go?
So more often than not, so most public companies are domiciled, it's known as domicile where they're organized, are domiciled in Delaware. The law is very well settled in Delaware, and that's one of the major reasons why they've just been around for so long, and there's so many cases there. And also the judges there are generally very sophisticated and know the ins and the outs. There's several courts there that are just profound for making the right sort of judgment and decisions. A lot of other courts, depending on the judges, that doesn't always happen. So, if there's no other reason to, Delaware is usually the place
The
where
go-to
entities
state.
get formed. And we see that a lot too, because a lot of times when we're doing international deals, we have to hire counsel, or our client already has counsel in foreign jurisdictions, and they're all usually pretty familiar with Delaware. So we would see that more often than not. And even for US deals, like you talked about raising capital earlier,
Mhm.
usually when capital is being raised, it's usually through a Delaware entity. Not always, but many, many times. There could also be some tax reasons to be in a particular state. So if you had a client that was going to solely be doing business in New York, for example, well, then maybe we just form the entity in New York. Because if we form the entity in Delaware, it would then have to, what's known as, register to do business in New York,
Mhm.
with the Secretary of State in the state in which companies are doing business, and then you have to file in duplicative states. You can avoid that by, if a company is really just doing business in one state, just have the entity domiciled there. But it really depends too. If they're doing a joint venture, where there's going to be more than one owner, that's a conversation that if the other entity, the entity that they're partnering with is a U.S. company, there may be some tax reasons why they may want to be in one state versus another. And there's some other reasons too, but I would say the default rule, if nobody's married to any other sort of state, Delaware is usually the place to go. New York is probably second.
Right.
Uh, and also, it gets into, I don't want to go beyond the scope of this, but then also, if companies are going to be operating here, they need to be thinking about which states have some more favorable laws for employers.
Mhm.
California is historically known to be very employee friendly, by far the most in the nation. So that's something and of course, there's so much big business out in California too, but that's something to be thinking about. Although most of the big companies in California are still domiciled in Delaware. All the big public companies on the New York Stock Exchange and the other exchanges are generally Delaware corporations.
Right. So that's a very common discussion that I have with clients as to where to incorporate. And obviously, like you mentioned, Delaware is a very popular first question. Well, why not Delaware? And there's no income tax in Delaware, or they look at Florida or Texas, and they say there's no individual income tax in those states. Why don't we just incorporate there? What they miss, I think, initially, because they're unaware as to the differences in operating in the United States and various jurisdictions, is that it's not like in Europe, when you go to France, you operate in France, right? And you're subject to French laws and regulations
Right.
and the tax code there. When you go to Germany, you're subject to the German tax code. So what I give them is typically, well, just think of the 50 states in the United States as kind of small countries operating under the federal umbrella, right? There's different tax codes and different tax schemes. And then if you incorporate in Delaware, or you incorporate in Florida, and there's no individual income tax there, but you're operating in California, or you're operating in Nevada, well, Nevada doesn't have any state tax also, but you're operating in a state like California that has personal income tax, you're still subject to personal income tax in California for the income that's earned in California. So different registrations, different layers of how to deal with employees and employment laws, labor laws, and operating kind of regulations in different states is a big consideration depending on
Yep,
what the company does.
absolutely. And I'd say generally, like the domicile for favorable tax states like Florida or Texas, we have clients that are Florida residents. So in those situations, it makes a lot more sense if they have businesses that they
Mhm.
be domiciled there. For foreign companies, it's not as big of a consideration. But it, really just depends on what the makeup, who the stakeholders are, who the owners are, where they're domiciled, and that sort of thing. But
Right.
if it's pure foreign, I think you'd see Delaware more than anything else. Just like in contracts with companies in the U.S. and companies overseas, you normally see either Delaware or New York or even California, just depending on the type of business, where those laws are generally used, and venue there is generally used as well.
Right, right. So yeah, when I had a recent conversation with the Ukrainian companies that is planning to enter the U.S. market, and they came to me with a question. Well, Delaware or Florida, right? And then I said, well, where are you going to focus your business operations? Like, what clients are you targeting? Where are your future clients going to be? And they said, well, probably on California, Texas, Nevada, Arizona area. I said, well, okay, then why would you incorporate in Delaware if you're going to be there? And there may be some good reasons to incorporate in Delaware
There
and
are.
operate in those states, but a
Mhm.
lot of times the more practical answer is, well, if you're going to be in Texas and for the foreseeable future, your operations are going to be in Texas, it's better to incorporate in Texas. It'll make things a
Mhm.
lot simpler for operating
Yep.
reasons and cost.
Yeah, but to the point earlier, your point about raising capital, if
Mhm,
their plan is to go out and raise capital, investors are very accustomed to Delaware. They're very comfortable with
mhm.
Delaware. So I would say more often than not, still recommend
Still recommend
forming in
Delaware. Yeah.
Delaware.
And I agree with that. And I guess that's the message that I really wanted to get across. There's no simple answer that works across the board. Different companies, depending on what their goals are, depending on their internal structures, who the owners are, where the owners are the owners going to be here? Are they going to be there? Are they hiring a board? What type of business they're in? Are they making products? Are there services? Are they going to be focusing on clients in one state versus another? Are they going to be
Hmm.
hiring people? All those layers become the conversation that we would have with the client, because sometimes you can't get to an answer until you start peeling back those layers, right?
That's why they need people like you and us and accountants and other sort of
Right.
professional advisors that are on the ground here that know the nuances and the differences and really sort of come up with a structure that's sustainable and is most appropriate and best for the business. And that changes sometimes, like we talked about earlier with the
Sure.
conversion statute and other sort of reasons that just depending on where companies are going to be. I mean, we see all the time too, the opposite, where we have US companies now that need to form entities abroad
Hmm.
for international operations. And that's, we have the inverse issue that comes up a lot. So, it's challenging, just depending on the particular circumstances. But I think the most important thing, though, to focus on are the tax issues, to be
Hmm.
consulting with the appropriate tax folks. Like we have folks on our team that are very sophisticated international tax advisors, and as well as ones here in the US. And, the other thing too is governance, especially, if the plan for a big company is just to say, all right, we're gonna form an entity here, we're gonna start operations here, and we're gonna move couple people over to the US and it's the same sort of folks, that's one thing. If they're really going to set up an operation that's going to be really operating completely separately, I mean, not completely because they're all part of the same
Right.
organization,
Right.
but with a different team, so to speak, than whether they went with an LLC or with a corporation. I think the governance of making sure that it's set up properly is really important, to make sure that there's a board in place and making sure that the I's are dotted and the T's are crossed, to make sure there's checks and balances in place.
Right. Okay. Well, before you know it, 30 minutes have passed. So I know we've covered a lot of high level information on the corporate formation, kind of what it is. What I'd like to do is hopefully you'll be willing to come back and talk about
Sure.
some specific details on specific company operations, maybe the documentation, maybe the bylaws, the articles of organization, just kind of dive into the details of what it's like to operate a company and some of the nuances that you have seen that worked for companies and didn't work for companies, right? And
Hmm.
I know every company is different, but I'd love to dive into some of those details with you to give people more tools and knowledge so they're familiar with, as they're speaking with me, as they're speaking with you, or if they choose to speak with another specialist, that's fine too. They're armed with the information as to what they should be asking
Absolutely.
for as they're
Yep.
forming their entities. So, Adam,
Absolutely. I'd
thank
be
you.
Thank you. Happy to help. Happy to do another round, more than one round, whatever you need.
Absolutely. 30 minutes do fly by quickly. So I appreciate it. We appreciate it. For everyone who's listening and watching, please email us with questions. Ask about any particular topics that you want to dive into a little deeper or unpack any particular information that's discussed. We'll be happy to do that via email. We'll be happy to do it in conversation. We'll be happy to provide another 30-minute podcast on the topics that you're interested in. So, Adam, thanks again. Appreciate it. Have a great rest of your day. And we're signing off.
Great. Thank you. Thanks to all the listeners and Alex. Thank you. And we'll talk soon.
Bye.
Take care. Bye-bye.